with the familiar premise that legislators cannot anticipate all fact situations to which the general rules they express may reasonably be thought to apply. Nevertheless, they can and probably do anticipate certain clear and paradigmatic cases, such as the operators of noisy automobiles taking Sunday drives through the public park. Their aim or intention is to prevent these occurrences by excluding such vehicles, but what of the unanticipated cases? In Hart views, the aims and intentions are here indeterminate. Although we agree with Hart, as Wallashaw puts it, it is better not be blindly predetermined, and that the question of what is to be done be left to the informed discretion of the judges, who can more fully appreciate and rationally settle in when it arises in a concrete case. We disagree with Will. We should not cherish, even as an ideal, the conception of a rule so derailed that the question whether it applied or not to a particular case was always settled in advance and never involved at the point of application a fair choice between alternatives. In a few words, the problem again is that Hart jumps to the conclusion that it is a matter of choice, not of judgment, and will amount, as already mentioned, to the exercise of a strong legislative or quasi-legislative discretion. For Dworkin, as Wallashaw would admit, it clearly does not follow from the thesis of open-ended nature of aims that the judge has strong legislative or quasi-legislative discretion. Let me stress that Wallashaw concludes the article by pointing out the vital difference between Hart's early standard position offered in both his Holmes lecture and his magna opera, the concept of law, and the later a third version presented in his entry for the Encyclopedia of Philosophy. In addition, Wallashaw clarified from the start that his aim was not to show that Hart's standard view changed, but that it should be changed in favor of the altered one. On one side, following the open texture of language, as well as the distinction between a course of settled meaning and the penumbra of certainty, Hart pushed formalism to one vicious extreme and ruleless scepticism, realism to the other, and tried, a la Aristotle, to get hold of the virtuous middle for his position. Determinacy in easy cases, which fall into the core of settled meaning, and indeterminacy in hard cases, which fall into the penumbra of uncertainty. On the other, following the criticism of both Fuller and Dworkin, the notion of open texture seems to have been replaced with the notion of relative indeterminacy or moderate indeterminacy. In Hart's voice, I'm quoting Hart. The clear cases are those in which there is general agreement that they fall within the scope of a rule, and it is tempting to ascribe such agreement simply to the fact that there are necessarily such agreements in the shared conventions of language. But this will be an oversimplification because it does not allow for the special conventions of the legal use of words, which may diverge from their common use, or for the way in which the meaning of the words may be clearly controlled by reference to the purpose of a statutory enactment, which itself may be either explicitly stated or generally agreed. Apropos of this, Wallashaw comments, so Hart now wishes to allow that the explicitly stated or generally agreed purpose of a rule can be used to determine whether a case clearly falls within its scope, and thus within the central element of settled law. On this account, even if the open texture of the term used in the expression of a rule causes indeterminacy, this can be sometimes be overcome by an appeal to other factors. Principles, for instance. If, for instance, it is clear that the obvious purpose of the rule will be satisfied only if the rule were taken not to apply in a penumbra case, then the rule just might now apply in that case. The law will provide full guidance despite open texture. In my sense, we can still get right answers. In fact, Hart seems to concede that the meaning of words may clearly be controlled by reference to purpose. This point was stressed originally by Fuller early on in his Positivism and Fidelity to Law, a reply to Professor Hart. It is rarely ever possible to interpret a word in a statute without knowing the aim of the statute. In Hart's words, it is of crucial importance that cases for decision do not arise in a vacuum, but in the course of the operation of a working body of rules, an operation in which a multiplicity of diverse considerations are continually recognized as good reasons for a decision. These include a wide variety of individual and social interests, social and political aims, and standards of morality and justice, and they may be formulated in general terms as principles, policies, and standards. In some cases, only one such consideration may be relevant, and it may determine decisions unambiguously as a determinate legal rule. Let me just point out that this is Hart in the Encyclopedia for Philosophy, 1967, repeated in 1983 with some addendums. And again, he's using the word may. So I grant him that he's consistent, but I still think that that falls short of what we need to describe our practice. Notwithstanding Hart's comeback in the postscript regarding judicial discretion, insists on judges having lawmaking powers and so judicial legislation. Quoting Hart, in any legal system, there will always be certain legal unregulated cases in which on some point, no decision either way is dictated by the law, and the law is accordingly partly indeterminate or incomplete. If in such cases the judge is to reach a decision and is not, as Bentham once advocated, to disclaim jurisdiction or to refer the points not regulated by the existing law to the legislature to decide. He must exercise his discretion and make law for the case instead of merely applying already pre-existing settled law. So in such legally unprovided for or unregulated cases, the judge both makes new law and applies the established law, which both confers and constrains his lawmaking powers. Hart further suggests, following Holmes, that such legislative powers are interstitial. It is important that the law-creating powers which I ascribe to the judge to regulate cases left partly unregulated by the law are different from those of the legislature. Not only are the judge's powers subject to main constraints narrowing his choice, from which a legislator may be quite free, but since the judge's power are exercised only to dispose of particular instant cases, he cannot use these to introduce large-scale reforms or new codes. So his powers are interstitial, as well as subject to many substantive constraints. Nonetheless, there will be points where the existing law fails to dictate any decision as the correct one, and to decide cases where this is so, the judge must exercise his lawmaking powers. Hart's insistence on the nature of such lawmaking powers and that they are interstitial, but legislative still, get him back over the shoulders of Holmes. However, the fact of being interstitial does not cancel it being legislative. As you can imagine, my feeling is that by appealing to a form of discretion that equates creative judicial activity to judicial legislation or judicial creation, Hart misses an important distinction, and we seem to be in danger of missing it too. The distinction that I have in mind among judicial activities is between interpretative and inventive, which correspond to a weak and strong form of judicial discretion. That is, between the weak discretion to interpret the existing law and even implicit principles and aims or purposes to be applied to the case at hand, and the strong discretion to invent, quasi-legislate, or legislate new law, or even to change the existing law. After all, Hart acknowledged, quoting Hart, judges do not push away their books and start to legislate without further guidance from the law. Very often, in deciding such cases, they cite some general principle or some general aim or purpose, which some consider relevant area of the existing law, can be understood as exemplifying or advancing, and which points towards a determined answer for the instant Hart case. Taking the distinction seriously implies that judges, instead of exercising a strong inventive or legislative discretion, pushing their looks book aside, do, and if I may add, must exercise a weak interpretive discretion by appealing not only to principles but also to aims and purposes in the quest for further guidance. The problems I find with Hart's arguments and his followers, in this case Will, is that the mean position, creative interpretation in between the extremes represented by non-creative interpretation, that is deductive or mechanical application, and creative legislation echoes his arch enemy, as Hart himself acknowledged. This indeed is the very nucleus of the constructive interpretation, which is so prominent a feature of Dworkin's theory of adjudication. But though this procedure certainly differs, it does not eliminate the moment of judicial lawmaking, since in any hard cases, different principles supporting competing analogies may present themselves, and a judge will often have to choose between them, relying like a conscientious legislator on his sense of what is the best and not on any already established order of priorities prescribed for him by law. Only if, for all such cases, there was always to be found in the existing law some unique set of higher order principles, assigning relative weight or priorities to such competing lower order principles, with the moment for judicial lawmaking be not merely deferred but eliminated. As Walucho advanced, Hart did not change his standard view on the subject matter, but I concur with him that it should be changed in favor of the altered one. Anyway, regardless of changing his view or not, I am convinced that there is a good reason for abandoning the standard view in favor of the modified version. That's the quotation from Walucho. Especially since the strong judicial discretion is incompatible, that's me, with Walucho's justification of charter review, which embodies a form of weak judicial discretion. I don't want to go into that part, not only because of time, but I think also Thomas had already did stress a lot of the quotations that I would like to emphasize from there. But let me just point to one in which Walucho summed up his paper and the community's constitutional morality. After arguing that constructive interpretation, which necessarily aims to place its subject in its best moral light, can be undertaken from a point of view other than that of the interpreter, that is, from the perspective of that community, I went on to argue, that's Will speaking, I went on to argue for the following claims. First, constitutional interpretation and review can be undertaken from the point of view of the democratic community and its community's constitutional morality commitments. This process can be undertaken by a judge without the deliberate intrusion of her own first-order moral convictions. Third, when undertaken from this point of view, constitutional interpretation and review can be rendered consistent with democracy. And fourth, this is so even when these activities require a good deal of substantive moral reasoning and argument on the part of judges. So my conclusion basically is that even though I'm still critical of Walucho inclusive legal positivism because of the might, so I fully endorse his living tree constitutionalism, and in that sense, I can also be labeled as an idiot. And so my contribution can be read as a homage from one idiot to another. And let me just end by referring to a personal anecdote, but just to the conclusion, because if I try to read it, it gets tricky. I think of Will Walucho, that Will Walucho is the HLA heart for many of us in our generation. Thank you, Will, my good friend and great inspiration. Cheers.
Thank you. Are there any questions?
I think people are getting tired, but
Yeah. No. Yes.
All right. Thank you.
Thank you. My question, I think it's maybe considered a very broad one, and I think it is addressed both to actually to Ima, to Walucho, and also to Thomas, which is in this last panel there has been a long discussion about and a comparison between Walucho's and Dworkin's ideas, and in Thomas' point that at the end of the day, it doesn't really, there's no real big differences in terms of what has been focused. And it seems that Emer somehow pointed out on the same kind of direction. So I was wondering, what is the point? I mean, if you are both of you stressing the similarities, and was the paper basically trying to map differences and similarities, or is there like a normative point behind it? And of course, I think this is also a question that could be addressed by Will, because you are the center of our discussion here. So it's a broad question addressed to all of three.
I can speak from my part on somehow I guess the only good thing I guess follow from the LP-ILP debate was that I made conscious that I was a Dworkin. I think my point I'm feeling is that I completely see why Hart, and I will say probably Kelsen, were like kind of stuck in this. We have to exercise a strong discretion. It is a matter of choice. So because they were stuck in this kind of on their terms on the relativity of values. So I think that was Hart's problem, that he had to refer to this is a matter of choice. This is quasi-legislative, legislative, and so on. And I think there was room for more things. And I have the feeling that will, especially in living tree constitutionalism, but even in some of these early papers, was hinting into the right direction. So somehow my sense is to point out that there was another route. But I know him, and he's very loyal to his mentor, and he will not say that he will follow the inclusive legal positivism, the soft positivism all the way. And that's, I think, as we saw yesterday, there's a point in which the inclusive legal positivism does collapse into working. And if not, they are not saying anything very important, very significant for practice. Saying that this might be, that this is a mere contingency, that they may appear principles. I don't see that. Even if I disagree with some decisions, I can see that they are citing principles. And I can see what Ken Ehrenberg was saying. Sometimes they get it right, sometimes they get it wrong, sometimes they void things that we clearly say, yeah, you're right. Sometimes they void things that you are like completely against. And I think that's part of the process of the evolution, which I think is very more related to the living tree constitutionalism. So I guess there is a normative point behind, and I think in that part where he refers to or points out that Hart probably didn't change the view, but at least in the encyclopedia. But and that's something I like very much. When people who have to write things for encyclopedia, I have the feeling that they step back a little bit and do more general statements. So I think that hint into take those paragraphs more seriously. And as I quoted, Hart referring to principles, policies, and other standards of morality. Like, this sounds more like working. And take notice that this is 1967, the year that finally the Model of Rules 1 was published, which was the original paper that Dworkin criticized Hart. So I think that there was some timely thing there. So I think that yeah, somehow there's a normative point that I think we have to agree that the law incorporates, entails this reference to morality, and that's what our practice do, even though people get it wrong. I completely agree on that. That's a different question, whether the law is determinate. I'm not sure necessarily saying that people get it right or wrong always. I think there's that part of the judgment, the discussion. And in that sense, I am also normative. I would like everyone to avoid trying to give explanations appealing to the strong judicial discretion. No, they are acting as legislators. No, I think that's a problem. And in that sense, defend the weak judicial discretion, which I think is compatible with all the things Will Walsh says, other than following Hart into the inclusive legal positives.
Yeah, no, it's okay. Well, I think that Dworkin was much more Hartian than Báez was, much more faithful to one Hartian idea, the eternal point of view. To understand the law, we must understand what the people are doing from the internal point of view. And what is it that people are doing when they undertake when they take up the internal point of view? Báez thinks, and Hart perhaps thought that too, but he's probably wrong about that. They believe that some criteria are binding and are a test of recognition of legal norms. But Dworkin would say, no, it's not that they are doing. They are doing something different. And the best way to understand it is look at page 68, 69 of Law's Empire, where Dworkin explain the attitude of a philosopher who is trying to describe an interpretive practice. And Dworkin says, he's like the man on the North Pole that is asked to go anywhere else but south. Because to describe the practice, you must participate in it. Because whatever you say about the practice will be used by practitioners as a way to understand themselves, the practice in which they are engaging. So it's not a belief, it's a commitment. People are undertaking a commitment to a certain test of validity and to a critical attitude that what Hart would call a reflective attitude. Dworkin would say, well, they should treat it as an argumentative practice because they should make their own judgments and argue about these judgments, submit these judgments to one another. This is what they're doing. So to make a judgment is not only to make some intra-mind evaluation, is taking up responsibility for a cognitive act. So it is something, at least in Brandon's reading of Kant and Hegel, it's something that we do. We make ourselves responsible for something to other people, and that's what we do. So I think that if we read the internal point of view in this way, Dworkin is the one that is taking up the internal point of view, because Raz is looking for beliefs of authorities, and I think that Will is in the middle. And I think that but I want to bring him to our side, because I think that his account of a community's constitutional morality is perhaps better developed than several things that Dworkin say about constitutional interpretation. So I want to inherit all the arguments that Will put in the book, A Common Law, Constitutionalism, because I think that not only constitutional interpretation, all interpretation of law, of morality, of statute is like the common law. We work under a practice and where there are several concepts, and we have to figure out the content of those concepts, how we do it, exactly in the way that Will said we should do to interpret the community's constitutional morality. So that's how I would answer to you.
Anyone else? Will, would you?
What do you think of it?
I'm not quite sure what to think. There's a lot of stuff that's been said here. I certainly don't think that my inclusive positivism reduces to Dworkin. I will continue to go to my grave thinking that's not true. But in terms of the affinity between my constitutional theory and Dworkin's, I'm willing to admit there's a lot of affinity there. I've got no problem with that. But then I'm not doing conceptual analysis, so to speak. When I'm doing constitutional theory, it's essentially normative. I'm arguing for a particular approach to constitutional adjudication and interpretation. I try as best I can to, well, I should say try. My claims are not about what's necessary most of the times. My claims there are what's possible and what's desirable. And on those grounds, but I can take on board a lot of what Dworkin says. I mean, it said, yes, these are good possibilities. That's why I wrote a paper once called Herculean Positivism, right? I mean, that was the main idea there, that there's so much there that's compatible. However, I wasn't willing to go the whole way that Emer wants me to go. So yeah, I mean, I can see that. And now as far as the discretion part of what you said, Emer, I remember once talking to Hart, and we were talking about strong discretion and about indeterminacy, and I was referring to the old example of no vehicles in the park. And I said, I don't think it follows from the fact that it's indeterminate whether that toy motor car is a vehicle, that the rule is indeterminate. And I think that, and he nodded and agreed. And I think that's what's behind, there are times when he makes it sound as if it's simply a consequence of, well, no, just a consequence of indeterminacy in language. And that is a central part of it, obviously. But I think he was taking steps toward acknowledging that legal systems are more complex than just single rules uttered by authoritative agents, and that their interpretation and their application can involve a whole range of different factors. But I think he continued to maintain that you can keep adding on all the stuff you want, you're still going to get points where the law sort of runs out. And on that, I'm in agreement with him. And that's why at the as my constitutional theory was developed, as I pointed out yesterday, I went from trying to show that there can be more determinacy than might appear to be the case because you got a CCM underlying the abstract provisions, and then I added on public reasons to provide more resources to find determinacy, and my very latest, my most recent work, I've tried to follow in the spirit that Katarina was talking about this morning, saying even if there is discretion, discretionary judgment being exercised at some points, you can still have democratic legitimacy. So there's kind of an arc there that in the way I've been thinking about these things.
Okay, so I'm gonna take advantage that I have the microphone. It's taking me 2 days to realize which is a question that I have, because whenever they're talking about morality and law, I feel like I'm barging in a started conversation, and there are things that have already been said and that I should just take at face value, but it doesn't convince me. So if I accept that a legal system should, maybe not must, and should have a claim of correction or some morality in it, I need to know first what is morality and why, if there is undetermination or there's the need to apply something more than the law, why am I going to use morality and not economical theory or medicine or common sense? Because if I'm talking about minimum wage, I want to talk about economical things and the how much money I need to make a living or to pay rent or whatever. If I'm talking about abortion, I want reasons of what implies to be a mother, maternity, even transportation, economic things, medical things. And when do I get to call for morality? Why? Why do I need morality and not the other things to judge or to value a norm or to apply something that has the pretension of being legal and therefore must be applied?
This will take like a 2 conference meetings to reply. But let me just try to suggest that in the field of general jurisprudence, this is probably the main discussion for us and that main part of the divide. And I would say that this has been since the classics, since this idea that they will probably talk about natural law and other names, justice and so on. So I think that's the part of what we have in mind is that either law works with rules or only rules, or at some point has to refer to something else. And we usually think that something else is embodied in this loose term. I can agree that it can sound loose in these discussions, that we label morality, which is, I think, the better term to avoid other complications to reference to justice or God and so on. So at least, and I think that's also one of the things I guess, be a great contribution. It's not that we are talking about the personal morality of any judge, which I think that's, I really not, I don't believe in that. Is the morality, the commitments of the people, of the community, and so on. So it's in some sense it can sound as similar to customary law, to ethics, and so on. But I think the term morality embodies this discussion, and that's like the clear division between the positivists and the non-positivists depends on whether we believe that there's a strong separation or not. And even if we can agree that there is a distinction, that there is some sort of separation, then the question comes into another discussion, which is whether the law and the morality are in the same system, so making it one system or two systems. So of course, there's a lot to say on this, but that's my own personal point. And yes, we were probably assuming that everyone was very familiar to the core of the debate being over the discussion on the role of morality in understanding the nature of law. But thank you for the question.
I'm not going to make a question. I'm going to answer your question. I'm sorry, I'm stealing your question, Zimmer, but I didn't get any. So I'm jealous. So I'm just stealing your questions. I think that the part of the reasons why, I'm taking up an argument by David Eisenhower. David Eisenhower said recently in a book that there is the mainstream position is to take up fixed content of morality and a fixed content of the law. So we have legal positivism in jurisprudence, and we have moral realism, but not a constructivist morality. So I think that we should have legal constructivism and moral constructivism. So why morality, not economics? The content of morality is not fixed. It's constructed through judgments and through argumentative social practice. And the same goes on with the law. The point is that the concept of law is a thick ethical concept. So it is impossible to describe without making moral judgments. You cannot describe liberty. What is freedom? Without evaluating things. You cannot merely describe freedom. And the same goes on with law, and the same goes on with morality. It's an interpretive practice. And we do both things at the same time because we cannot separate our brains. We think about morality and we think about the law. So if we are constructivists, there's no problem. It is still possible to distinguish law and morality in a sense, because law is the content of the moral rights that stem from the past actions of political institutions. The institutions, they did not say or believe anything. They did some things, and those things that they did, they have a moral impact in our lives. How do we determine this moral impact? Not, as Greenberg says, by looking at a metaphysical morality, but by arguing in a moral practice that is also a legal practice. So that's the reason why morality, not economics, because depending on the moral judgments that we make to interpret the law, I can put you in jail. I can take the custody of your son. I can take all your money. In some countries, I can kill you. So I cannot kill you or take the custody of your child or put you in jail because this would be in the interest of the majority, or because this is a good policy, because this is going to be coercion. This is going to be the force of the whole force of the community. The only authorized force is that imposed through the law. Well, only moral reasons, not policy arguments, can do that.
Or to answer your question more simply, is you can't have economics without morality. You can't have morality without economics. If you want to say, we want to figure out the justice of either having or not having a minimum wage, you need economics to tell you what the consequences will be of having it. But if they say, look, if you have a minimum wage, a certain number of workers will have more money, a certain number of workers will be forced out of work, it'll have the following effect on trade, it'll have the following effect on GNP. Whether those all add up to a good thing or a bad thing requires moral evaluation.
Could I add one just follow up on what I think of what Brian was saying and a little bit about what Thomas was saying. And ties, I guess your question was why, when judges exercise discretion, we should talk about morality only? Yeah. Well, mainly because judicial decisions impact people significantly. And when we are moral agents, as judges are, they have to consider the morality of what they're doing. Now that sometimes requires, as Brian pointed out, they might have to consider the economics of the situation to find out, particularly if it's a particular question of a particular kind. But this might sound kind of crazy coming from a legal positivist, but all legal judgments are, in my view, moral judgments, and morality sometimes dictates that the judge decide in a particular way, and given the judge's role in the entire enterprise, his moral duty is to decide as the law requires, even if he doesn't agree with it. But when discretion is in play, then there could be all kinds of different things that she could apply to the judge. But in doing so, she will be directed by the thought that what her decision is one that affects significantly the interests of particular individuals, and that's always going to be a moral judgment. So that's why morality is always important when it comes to discretion.
Anyone else?
Hello, I have only a simple question for both of you. Does this morality really exist, or is this morality only a pretension of morality? Like, for example, Christoph Müller's in Der Möglichkeit der Normen sustain.
I think it's part of the practice, even though if you want to grasp it, I don't think you will be able to grasp it. But if we keep discussing this is wrong, this is right, and so on, I think it's somehow there. And I don't mind talking about justice nor natural law and so on, but I think those are more terms more problematic even than morality. And I like the sense that, and that's one of those things I like of Will's work, is that he's saying, well, to talk about the community's constitutional morality, which are the commitments that we have as a community. So there has to be something. I know some people might be a skeptic, but I still have the feeling that they have to believe in something being there. So I can say, I can agree, concede that it may be pretentious or pretended or the claim of correctness and so on. So even though the laws are not correct, we'll still be talking of them as being correct or being arguably made to be correct, to improve our lives, to regulate our lives, to guide our lives. So I think that's, probably I'm not answering to what you really want to hear, but I think that's there. That's part of our practice. All the time, judges are deciding cases, and let me quote, for instance, Dobbs. Dobbs in the US withdraws what was for 50 years very clearly recognized as a right for the woman to have an abortion. And then they decided to overturn that decision. And let's see how many years it takes to overturn that decision again. So I clearly have the feeling that we have a sense of which one was right and which one was wrong. So again, I think it's there. It's part of our practice. And even though I cannot necessarily guarantee that I have the right ones, I think that's part of our reference.
Okay.
Yeah, sure.
I was going to pick up on this because Emer reminded me that in what he said of something I wanted to say earlier in response to Ken Ehrenberg this morning. I clearly distinguish between my inclusive legal positivism as a conceptual theory of law and my constitutional theory. And Ken seemed to suggest, at least it seemed to me that he was saying that my inclusive positivism now is the view that the community's constitutional morality can serve as a condition of validity. That's not the view that I endorse as a general jurisprudential position. My position is that morality of any kind can serve as a condition, and could be constitutional morality, could be true morality or Platonic morality, whatever you want to call it, or it could be some other form of morality. When I turn to constitutional theory, I'm arguing for a particular type of morality that should be used in adjudicating cases to solve the puzzles that I set myself in developing the theory. So so my view is not that ILP is committed to constitutional morality as the possible condition of law. When I say that morality can count, it could be any kind of morality.
Thank you. Okay.
Oh, Ken's there.
I think you can just open the microphone and start asking. We have Ken Ehrenberg first, and then Matthew Kramer. No.
Yeah, can you hear me?
Yep.
Yes.
Yeah, so I just wanted to reply on that. I didn't mean to saddle you with the idea that it was necessarily the CCM that you were implying. I was just trying to I was using that. First of all, I think that I thought there's more continuity between your constitutional theory and your inclusive legal positivism there. I think it's for you, I thought it was a kind of, an interlocking picture. It's not that one depended on the other, obviously, because your inclusive legal positivism, your brand could be accepted by people who don't accept your constitutional theory, and that's clear. But I thought that in a way I also was being as charitable as possible from a exclusive position to try to see where you were splitting the difference, how your articulation of the CCM is kind of splitting the difference between a reliance on the on positive morality, which is in some sense empirically ascertainable, and on this kind of what you call Platonic morality, which is not empirically attainable or ascertainable. And so that was, I think, in many ways, for that part of the debate between the ILP and ELP, that was the kind of the strongest position that I needed to reply to,
Okay.
which required mentioning your constitutional theory in order to set up the strength of that position. Right. Because if you're talking about Platonic morality, then it's, then we got other problems, as you rightly point out. And if you're talking about purely empirically discernible positive morality, just moral beliefs even, then there's no daylight at all between ILP and
That's right.
ELP.
That's right.
So in order to make the daylight, it has to be something more than just moral beliefs. But if you go to Platonic morality, you got those other problems. So I thought that was the strongest position available. And that's why I was trying to meet you there on that strongest position.
Okay. Yeah. Good.
Okay. Thank you, Matthew Kramer.
Right. Well, I think what I was going to say is largely in accordance with what Ken has said, because in my replies to Pierluigi Chiasoni in Without Trimmings 2 years ago, I maintain there that inclusive legal positivists and incorporationists really have to be moral realists, as I am, if their legal theory is to be distinguishable at all from a version of Raz's exclusivism, because Raz and his followers readily accept that conventional norms, positive norms, even if they're moral in content, can enter into the law or can be legal norms. So if it's only conventional or positive morality, even tidied up a bit, then there's not going to be a distinction between ELP and ILP. And so if there is to be such a distinction, I think each side has to be committed to moral realism. If there's something for ELP to deny, and if there's something for Will and me to affirm. And so I'm basically agreeing with what Ken has said, at least if I've understood correctly what he said.
Okay, thank you. I know you have a question or an answer, but we have to wrap it up. So, I thought you did. Okay. So.
Okay, well, thank you all. Thank you both Ken and Ehrenberg and Matthew Kramer for staying both days completely, and especially since the time zone difference. So we really appreciate that you engaged in the discussion and so on. And everyone here, thanks again for joining. And people who follow us in Zoom and also in the YouTube and the Facebook, there has been some technical problems, but this is recorded and they will be retransmitted. So that's the good part, the good news. So I will not only just give this thanks on behalf of the Dean of the Law School, Sonia Venegas Alvarez, and the coordinator of the graduate program of UNAM in law, that's Marisol Anglés, and of course of myself as the dean of the graduate program at the law school. It has been a wonderful discussion, a really nice conference, paying tribute to when I think is really, as I said before, the heart of our generation. And really, I believe that you have raised the bar for everyone else. So I'm very happy that we were able to do this, and especially congratulations to Thomas for the book and everyone who contributed to it. And yeah, the idea was also to launch the book, but I hope it contributed to that as well. So people will be interested in reading it and getting to know much of your work.
I'm going to get emotional here. Thank you so much. I really, really appreciate this. This is truly an honor to have this event take place, and I'm so grateful for the contributions. And Ken, Matt, thank you very much for your contributions. It means a lot to me. And thank you, Emer, for organizing this. It's been a lot of fun. And Thomas, thank you so much for the book. I can't tell you how much that means to me. Thank you.
Thank you. Right. Well, could I express thanks, of course, to Will as the honoree, but also to you, Emer, and to everyone who collaborated with you in bringing this event about, because I'm most grateful for any opportunity to express my esteem for Will. So thank you for giving me and everyone else that opportunity.
Hear, 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 hear.
Thomas wants to say something, but it has to be quick.
It's very, very quick. Just to add the thanks to Saulo de Matos and André Coelho, who are also editors of the book, and they had this idea, and it ended up here. It's a real honor for me. And thanks, Emer. I think that this will bring visibility to the book, despite the difficulty that we're having to get it spread. But we will make it more public and more available to everyone. And also thanks very much, Ken and Matt Kramer, for this wonderful contribution to the seminar. Thanks once again, Will and Emer.
Welcome. Thank you. Thank you all. Thank you.
Recording stopped.